Good evening, ladies and gentlemen. How are you? Thank you for joining us for part two of our session with Colbert and Grievous. And this evening's topic is long-term care planning and why it is important. So I'm going to make the general introductions and thank you for joining us again. And I will turn it over to Kevin in a moment. So to give you a little bit of background, Colbert and Grievous is an elder law firm dedicated to serving the legal needs of seniors and people with special needs in our community. The firm was founded by Brenda and Kevin in 2012 with three foundation principles, and they are: first, Brenda Colbert and Kevin Grievous wanted to bring a high level of experience and expertise to the local practice of elder law. Brenda and Kevin have both been practicing elder law since 2002, and they are both certified as experts in the field of elder law by the National Elder Law Foundation. In 2022 through today, both Brenda and Kevin were selected as Pennsylvania's super lawyers. Second, Brenda and Kevin want to provide their expert services locally here in northeastern Pennsylvania. Community is very important to Brenda and Kevin, who live, work, and raise their families here in NEPA. Because they keep their practice local, they are more accessible to their clients and families. The firm helps to support the local economy and charitable organizations. Brenda and Kevin understand the unique values and goals of the people who live in NEPA, and they both have a vested interest in the well-being of their clients. And finally, the third foundation principle of Colbert and Grievous is to bring peace of mind to their clients, families, and the NEPA community at large. In their over 22 years of practice, Brenda and Kevin have witnessed time and time again the devastation that comes when a loved one requires long-term care. They recognize that community, education, and providing the facts about paying for care needs would go a long way to easing the minds of their friends and neighbors. They have been committed to separating fact from fiction in plain language to bring peace of mind to their clients and to the community as a whole. So please join me in welcoming Kevin Grievous. Thank you.
Thank you. All right. Good afternoon, I guess. It's 5 o'clock. It's still pretty much the afternoon. Thanks for being here. Thanks for those online who are watching as well. Again, my name is Kevin Grievous, and I'm a certified elder law attorney. What I'm here today to do is give a little presentation to you about long-term care planning and why it's so important. I was here last month, and my partner Brenda Colbert and I talked about estate planning in general, making sure that everyone has the correct legal documents in place, like wills and powers of attorney, and for some people, trusts. So that was our discussion about a month ago. But today, I want to focus on a topic that's extremely important, and that is planning for long-term care. But I want to start out in general with what constitutes elder law issues. So let's see. All right, we're sideways, down? Oh, there we go. I think we got it. Okay. So we consider elder law issues to encompass 4 areas: planning for incapacity. So in the event that you become incapacitated in the future and can't make your own decisions, you have the right sort of documents in place to do that. Also planning for death, of course, and that's the last will and testament. I have a little technical difficulty here. Yeah, absolutely. Thank you so much. Sure. You must have the Midas touch. I don't know.
That bottom button will hide it.
Oh, can't touch the bottom button.
That's
okay. All right. Thank you. All right. Planning for long-term care needs is really what we're going to spend the majority of our discussion on today. But also we have special needs planning. So these are the areas that really encompass elder law. So I want to give you a brief overview first of planning for incapacity and death. This is kind of like a review of the things we talked about last week, or last month, I should say. So healthcare decision-making, making sure we have a healthcare power of attorney and an advance directive in place. So you get to choose the person you want to make medical decisions for you in the event that you become incapable of doing so in the future. And that's done through a healthcare power of attorney. The healthcare power of attorney can also contain a living will, which is the portion of the document where you're directing the types of care that you would want to have withheld or withdrawn in the event of a terminal illness and incapacity. So that's kind of a building block document that everyone should have regardless of their age. The other important lifetime document that everyone should have in place is the financial power of attorney. And this aids in financial decision-making. So this is the document where you execute, where you appoint another person or persons to handle your financial affairs for you if you need assistance. The document is generally effective as soon as you sign it, so it's not like you have to be incapacitated. Most people will choose their spouse as their power of attorney and then maybe a child as the successor. It's a very important job. It's going to be the person who's in charge of all your financial affairs if you become incapable of handling them for yourself. So those are some important issues for estate planning in general, but I really want to focus on long-term care. That's really going to be our topic for today. So I'm going to start out with something really basic, the definition of long-term care. So really, what am I talking about with long-term care? I think when most people hear that term, they automatically think of a nursing home. And yes, a nursing home is a place where long-term care supports and services can be provided, but it is the last stop on the long-term care continuum. It's appropriate for a person who needs considerable assistance with their activities of daily living and cannot in any way, shape, or form live on their own. But there's also lower levels of long-term care. There's personal care and assisted living, which is appropriate for a person who maybe is still not safe to reside at home, but they're not yet ready for that level of care that's provided in a nursing home. But of course, most people, if given the opportunity, would rather stay home. You know, I've been practicing for about 23 years, and believe it or not, I actually have met a few people who wanted to go to a nursing home. It's only a couple over 23 years, but there's only been a couple people who wanted to do that. So most folks want to remain independent. They want to stay home in their own residence as long as possible. And it's good to know that there are alternatives that will allow that to happen. People can either pay privately for care in their home, or they can qualify for benefits that will help pay for that care in their residence and allow them to remain independent for as long as possible. So those are the different settings that long-term care services can be provided. But now I want to talk about how people pay for this. And what I'm really going to focus on is care in a skilled nursing facility. How are people paying for that? Well, first of all, Medicare is one of the payment sources. But how many people think that Medicare is a long-term solution? Right? It's not. Medicare is very limited. For Medicare to cover you at all in a skilled nursing facility, you have to have what's known as a 3-day qualifying hospital stay prior to your admission. So not only are you going into the hospital for observation, you actually have to be admitted. And you have to be admitted for 3 days before Medicare will be activated to pay for your care. And if you are a traditional Medicare beneficiary, Medicare will pay 100% for the first 20 days. Beginning on the 21st day, if you have Medicare and a supplement, as long as you still need skilled care, Medicare will pay a portion and your supplement should pick up the rest. And that can go on for another 80 days maximum. So total between full Medicare coverage and Medicare and supplemental coverage, you're looking at 100 days. But those of us who practice in this area, and I'm sure many of us here realize, very few people are going to get the full 100 days from Medicare and your supplement. Most people become private pay relatively quickly because a determination is made that they don't need skilled services anymore. They just need custodial care. And when that happens, you must switch to one of these other payment sources. And of course, one of them is paying privately. So right now, the average cost of 1 month in a nursing home in Pennsylvania is just over $12,000. So if you have to pay privately for an extended period of time, think about how quickly you would go through your savings, your retirement, your investments, covering the cost of that care. For many people, that's a devastating reality to go through that. So it is very expensive, and some people, though, will be forced to pay privately. Now, there are some other options. Some people have long-term care insurance. Now, this is not something that I sell. I'm a lawyer. I'm not an insurance professional, but I do review policies for people to determine whether those policies are the best policies for that individual. So long-term care insurance is basically you're buying insurance to cover a future long-term care need. And there's traditional long-term care policies where you're buying coverage, you pay the premiums your entire life, And if you never need long-term care, you get nothing back. Those were the traditional policies. Well, guess what? There aren't too many of those around anymore. Insurance companies don't really sell very many of those. So now most long-term care insurance policies are what I would call hybrid policies, meaning it's actually a life insurance policy with a long-term care rider. So once you buy this policy, you have a guaranteed death benefit. And even if you never go into a nursing home and never trigger the long-term care side of the policy, your family will still receive a death benefit upon your passing. So that's far more attractive to most people, and it's more affordable. And beyond that, the underwriting requirements aren't quite as strict as for traditional long-term care insurance. However, most people do not have long-term care insurance in any form. So that's where we turn to the fourth method of paying for care, and that's a program called medical assistance, otherwise known as Medicaid. Medical assistance, and in Pennsylvania, as they said, the term is Medicaid, is a federal and state program that does a lot of different things. And I know Medicaid has been in the news a lot lately in terms of potential cuts to Medicaid. Those cuts are not currently directed so much towards the nursing home side of things as they are towards other types of Medicaid, but they may still be felt in the future. But in any event, Medicaid is the key to paying for long-term care. It's also the key to protecting your resources. So what I want to do is talk about some of the Medicaid eligibility rules. So to qualify for Medicaid or medical assistance to pay for your long-term care, you have to meet the financial eligibility rules. And there are a whole host of rules to qualify. Now, if a person is in a nursing home and they want medical assistance to pay for their care, what do? They have to file an application with the county assistance office. So, and on that application, they have to disclose all of their financial resources. Everything has to be told to the county assistance office. And what's going to happen is certain assets are considered countable and other assets are considered exempt. I'm going to go backwards. I'm going to start out with the exempt assets. So when a person is applying for medical assistance to pay for their nursing care, they're permitted to keep the exempt resources. Exempt resources will have no impact on their eligibility for care. So what are the exempt resources? The largest exempt resource is actually your primary residence. Now, most people have heard the horror stories. They think the nursing home is going to take your house. They are not going to take your house. As long as you express an intent to go back home, even though that might not be realistic, the home is considered to be an exempt resource. However, that doesn't mean the home is definitely safe, because when a person who's on medical assistance passes away, Pennsylvania is going to come back looking to recover the amount of money they spent on your care. And at that point, your home could be at risk. But up front, when applying for medical assistance, the home is considered to be an exempt resource. Also exempt would be the contents of your home. All the stuff inside your house, your personal belongings, your furnishings, clothing, collectibles, and even one automobile. One car, regardless of value, is exempt. Also exempt would be burial plots for yourself and your immediate family, and you can prepay for your burial arrangements by setting up an irrevocable burial account. That's also exempt. So those are the things that you can keep and still qualify for medical assistance to pay your nursing home bills for you. So what is now countable? What's at risk? Well, pretty much everything else. So your money is at risk. So cash, checking, savings, stocks, bonds, mutual funds, whole value life, cash value life insurance, retirement accounts, your second automobile, if you have a second home, all of those things are countable in determining your eligibility for medical assistance. And if you are a single or widowed person, you've got to decrease your countable resources all the way down to $8,000. And for some folks, all the way down to $2,400. So think about your savings, your checking, your retirement, your life insurance, your CDs, your stocks. And if you had to deplete that all the way down to $8,000, many people would have a lot to lose before medical assistance is going to pay for their care. So that is the resource eligibility rules for medical assistance. Now, it's good to note that the rules are slightly different when there's a spouse. There is something called the spousal impoverishment rules. So Medicaid or medical assistance has rules that try to prevent the healthy spouse from becoming impoverished. These are called the spousal impoverishment rules, and they apply to resources and income. So I want to walk you through how this works if a married person is admitted to a nursing home. How does that person go about qualifying for medical assistance benefits? So remember I said earlier your assets are allocated into either exempt or countable. So in a married context, all of those exempt assets can be retained by the healthy spouse. So a healthy spouse will keep the house, the car, the contents of the house, the burial funds, and a couple of other things too. The healthy spouse is automatically permitted to keep all of his or her own retirement money. So if the healthy spouse has an IRA or a 401k or a 403b, the healthy spouse gets to keep all of it. Doesn't matter how much money is in it, they get to keep the entirety of that. Okay. But everything else is still initially countable. All the joint assets, the joint bank accounts, all the savings, the life insurance, the ill spouse's retirement, the second car, all of that stuff is countable. And what we do is the community spouse, the healthy spouse, is permitted to keep some of those countable resources. And that's known as the community spouse resource allowance. And the community spouse resource allowance is equal to 50% of the countable resources that exist on date of admission to the nursing home, with a major caveat. So what we do when someone enters the nursing home, we look at all their countable assets that they have on the date of admission. And if they're married, their spouse gets to keep half of those countable resources. But there is a maximum community spouse resource allowance. So it's not an unlimited 50%. So basically, the maximum community spouse resource allowance changes every year. Right now, it is $157,920. So that's the maximum amount that the healthy spouse can keep, no matter how much in resources the couple has. So it doesn't seem fair, does it? But what I want to do is I want to illustrate this with a couple of examples to really drive it home. So let's say we have one couple who has one house, one car, and $100,000 in the bank. That's all they have. One of them goes into the nursing home. What is the healthy spouse allowed to keep? Well, we know that the home and the car are exempt, so the healthy spouse will keep both of those items. And in fact, those items can be transferred to the healthy spouse. But what about that $100,000 in the bank? That's countable in determining eligibility. And under these general rules, the healthy spouse can keep 50%. So 50% of $100,000 is $50,000. So in this example, the healthy spouse will keep $50,000. The remaining $50,000 is considered to belong to the spouse in the nursing home. And that has to be spent all the way down to $8,000 before he or she will qualify for medical assistance. So this hypothetical couple has to dispose of $42,000 before Medicaid eligibility will be awarded to pay for care. Now, do they have to spend that $42,000 on the nursing home? Fortunately, they do not. They can spend that money on any goods or services that benefit either spouse. So if there's any marital debt, if there's still a mortgage or a car payment, they can pay that off with that at-risk amount. They can actually buy something new. If the healthy spouse needs a new vehicle, he or she can buy a new car. They can make household repairs. They can do any purchases of items of goods and services for either spouse. So they don't have to spend it all on the facility, okay? So that's one example, one potential couple. Another potential couple, let's say couple B has one house, one car, and $500,000 in the bank. So now what? Well, again, we know that the home is exempt and the car is exempt, so the healthy spouse will keep both of those items. But what about that $500,000 in the bank? Well, under the general rules, the healthy spouse is permitted to keep 50%. Well, 50% of $500,000, of course, is $250,000. But that exceeds the maximum allowed by federal law, which I said to you a few minutes ago is $157,920. So in this example, this healthy spouse is not going to actually get half. They're going to get far less than half. They'll be capped at $157,920, and the rest will be countable over, $300 and some thousand dollars is now countable in determining eligibility for that ill spouse. And it's a lot harder to spend $300,000 plus than it is to spend the $42,000 on items of goods and services. So this couple has a lot more to lose, and their planning to protect that money is going to be far more complex, but it is possible to protect some additional resources. Now, we've talked about resource eligibility for medical assistance. There is another part of eligibility for medical assistance, and this is the rules pertaining to gifting. I'm sure most people have heard of what we would call the 5-year rule, right? So I want to explain exactly how that works. When a person is applying for medical assistance to pay for their nursing home care, they are required to disclose all the gifts they've made during the prior 5 years. All those gifts must be disclosed to the county assistance office. Gifts made outside of the 5-year window don't have to be reported and will have no impact on eligibility. But gifts inside the 5 years must all be reported, and we add up all those gifts and we come up with a total amount of money or assets that were gifted away during the 5 years. And then Medicaid will apply what's called a transfer penalty period. They'll say, well, this person had X amount of dollars, they could have spent it on their care, but they chose to give it away. So we're going to make that person ineligible for medical assistance based on how much they gifted away. And there's a precise formula that's used to make that determination. What the state will do, they will take the total dollar value of the gift and divide that by the average monthly cost of nursing home care in Pennsylvania, which is currently $12,160. That will tell us the amount of months that a person is ineligible for medical assistance. So put another way, for every $12,160 you give away, you create 1 month of ineligibility. So let's say you gave away approximately $25,000. That's 2 months of ineligibility. $50,000 would be 4 months of ineligibility. $100,000 would be 8 months of ineligibility. Now, when does that ineligibility period start? That ineligibility period does not start when I make the gift. It starts when I'm in the nursing home and I'm otherwise spent down to my resource limit for Medicaid. So basically, I have only $8,000 left in my name and I'm already in a nursing home. So if I'm in a nursing home and all I have left is $8,000 and I still have an ineligibility period of 8 months, how am I going to pay for my care? It's almost an impossibility, right? Well, there is something called the Family Responsibility Act. This is a law that was passed in Pennsylvania many years ago, but it actually was just recodifying existing law in Pennsylvania. And what this basically says is that certain family members bear a responsibility to pay for their indigent family member's care while that person is in a nursing home, if that person doesn't have insurance coverage and doesn't qualify for Medicaid. So basically, it imputes liability on certain family members. And who are those family members? Spouse, children are the primary ones, spouse and children, and parents, okay? Now, most people in a nursing home, they don't have parents who are living, so that's not often applied to parents. And quite honestly, in a situation like this, most often there's not a spouse either. Usually it applies to the children. So you can have a situation where you have a parent who's in a nursing home and is ineligible for Medicaid because of prior gifting, and they have no money to pay for their care. The nursing home has a cause of action under the law against all the children to bear financial responsibility, not just the child who got the gift, who created the penalty, against all of the children. So it's not based on who got the money, it's based on the family relationship. And that's why it's called Filial Responsibility or Family Responsibility Act. So I bring this up because it's an important concept, and I want people to understand that it's okay to make gifts. Listen, I'm a parent, many of you are parents, we want to help our children. It's a natural inclination, but we have to be careful. We don't want to just make a large gift, create a huge period of ineligibility, and have no way to pay privately for our care during that period of ineligibility. So gifting can still be done, but it should be done in a carefully planned way. So another key concept for medical assistance is something called the Estate Recovery Program. So remember earlier on, I spoke about the fact that the house is exempt when you're applying for Medicaid benefits. The value of the house is not going to count against you. You can still be in a nursing home receiving medical assistance, and you can own a home at the same time. That is true. But when you pass away, if you are the sole owner of your home, if no one else's name appears on the deed with you, the home becomes part of your estate and thus becomes subject to what's called medical assistance estate recovery. Pennsylvania is mandated by federal Medicaid law to seek recovery against a deceased Medicaid recipient's estate. They're trying to claw back some of the money they spent on care. And if they're spending $5,000, $6,000, $7,000 a month on care, it's a significant amount of money. So medical assistance estate recovery applies primarily to the home. So the idea is, for most people, they don't want this outcome. And thankfully, there are many things that people can do in advance to avoid or very much limit the risks of being subject to medical assistance estate recovery. Really what it's going to come down to is that person not being the sole owner of the home at the time of their death. So how do people plan to protect themselves, to protect their spouse, to protect their children from these costs? Well, there are two pathways to planning, and the first one I'm going to address is the best one. It's advanced planning. Not waiting for a crisis, but rather planning ahead of time to make sure that you can protect as much as possible and retain as much control over your estate as possible. And advanced planning involves one of two options: buying insurance to pay for long-term care, or making gifts to divest yourself of assets. So in the future, when you do need medical assistance, you don't have the assets to prevent you from qualifying. So those are the two pathways. I talked already about long-term care insurance, and I do think it's something that some people should consider. So who should consider long-term care insurance? I would say an individual or couple who have a high guaranteed fixed income in retirement, and an individual or couple who has a significant amount of their net worth made up of retirement money, like IRAs, 401ks, 403bs. Those are the people who might want to consider long-term care insurance. And don't wait till you're 70 or 75. Look for it and look at it when you're 60 or 65 or maybe even 55. That's the time to look into it, because it's going to be far more affordable, easier to purchase, less health concerns, less underwriting issues to concern ourselves with. But still in all, most people do not buy long-term care insurance. So the other option is to make gifts and get assets out of your name and stay healthy for the 5-year look back. So how do we best effectuate those gifts? Well, back in the day, right, 30, 40 years ago, people would just sign their house over to their children. They would give their investments and their stock, just sign them over to their children. We don't recommend that. There's too many risks involved with just giving your estate away. If you give away your assets to your children, that is a completed gift, and those assets become subject to your children's own potential liabilities. It's not a good idea to do that. There's also some negative tax implications to just giving away assets without any strings attached. A better way to facilitate gifting of assets is through a specialized type of trust that we call a family asset protection trust. There are many different kinds of trusts that exist. This trust has to check a lot of different boxes for it to work effectively. So this trust basically is going to become the recipient of the gift. Rather than gifting your home, your investments, your life insurance, your stocks, your CDs to your children, they're instead gifted to a trust. Because a trust has no liabilities. A trust isn't going to be sued. A trust obviously is not going to get divorced. So a trust is a safe place to gift, to transfer your assets to. So how is a trust established? Well, a trust is established either by a single person or a married couple who are looking to protect their resources. They would sign an irrevocable trust agreement with another person who would be known as the trustee. The trustee is simply the manager. They're the person who operates the trust. They don't own anything. So for most of my clients that I'm counseling in these matters, they're going to pick one of their children to serve as the trustee. So you have a set of parents, a married couple, signing an irrevocable trust agreement with one of their children, establishing their family asset protection trust. Think of that trust like it is its own legal entity, like a business or a corporation. It has its own tax ID number, and it can own assets just like we do. So once the trust is established, the people who are looking to protect their assets transfer ownership of assets from their name into the name of the trust. So they deed their property into the trust. They transfer ownership of their life insurance, of their stocks, of their investments, maybe some annuities, CDs, other types of cash resources. And all of those assets stay exactly where they are. We're just retitling them into the name of the trust. And the action of doing that starts that 5-year clock ticking. So if I set up a trust like this when I'm 70, and I put my house and my assets in the trust, by the time I'm 75, that's all protected from my future nursing home expenses. And once the assets are in the trust, it is true that I can't take them out. But my child, who's the trustee, can, with my permission. And maybe those assets don't ever have to come out of the trust. Maybe they stay inside the trust. And then when I pass away and my spouse passes away, the children inherit those assets from the trust, just like they would through your will. And there's no estate recovery. So even if I and my spouse had been on Medicaid paying for our care, the assets in our trust are exempt from the Commonwealth's estate recovery claim. They're going to pass out to our beneficiaries without passing through that claim, no probate, directly to the beneficiaries. So there's a lot of benefit for a lot of people in considering creating a family asset protection trust. There's so many different variations on how the trust can be established and who the beneficiaries are, but the common thread is it has to be irrevocable, and the people who create it cannot on their own reach in and take assets out. But there are ways that assets can be released from the trust over time with their permission. And one question I'm often asked by clients and by people I'm just speaking to is, if I appoint my daughter as the trustee and she and I have a falling out, or she doesn't want to, do something I ask her to do, what's my recourse? Well, you can actually remove the trustee. You can fire the trustee and appoint somebody else. So there is that ability to maintain some amount of control, sort of indirectly, by having the power to remove a trustee. And you can even change the beneficiaries to some extent on the trust too. So even though the trust is irrevocable, there are things you can change and modify over time as the creators of the trust. So I would tell you that right now, in my opinion, using a family asset protection trust is probably the best advanced planning strategy that we have. Now, it's important to note that not everyone plans in advance. Not everybody knows about insurance or knows about using a trust or even thinks about giving away their assets to protect them from future nursing home expenses. So it is possible to also plan in a crisis after someone enters a nursing home. And I'm going to start out with a general proposition. In general, as a certified elder law attorney, if I meet with somebody, a single or widowed person who's done no prior planning, made no prior gifting, and they're already in a nursing home, we can usually help them legally protect about 50% of their remaining assets. And with a married couple, we can often help them protect 100% of their remaining assets, even after admission to a nursing home. So how do we do that? Well, when someone is looking to qualify for medical assistance, the first thing we're going to do is a spend down. They have too much money to qualify, so we're going to advise them to spend some of that money on things they need, like prepaying for their burial, setting up that irrevocable burial fund, possibly paying the nursing home while the plan is getting off the ground. But for a single or widowed person, there is a way that we can actually allow them to make a gift to their family even after they're in the nursing home. We calculate the exact amount of money that can be gifted. That gift will create a penalty period, a time during which they're not eligible for Medicaid. We reserve enough money to pay privately for their care during the pendency of that ineligibility period. We have to buy something very special with that to create an income stream, and that's called a Medicaid-approved immediate annuity. So by using a Medicaid-approved immediate annuity, we can preserve about 50% of the resources for a single or widowed person. For a married couple, we can protect even more. So remember my example earlier on when I said we have a couple that had a house, a car, and $500,000 in assets. How do we protect that extra resource? Well, remember, the home and the car are exempt, and so we could transfer those over to the healthy spouse. But of that $500,000, only $158,000 of that is protected automatically for the healthy spouse. So that still leaves, what, $340,000 or so at risk to pay for the ill spouse's care. So instead of spending all that money on the care, what are we going to do? The first thing we're going to do with that $340,000 that's at risk is we're going to do the spend down. We're going to buy the burial funds. We're going to pay off the marital debt. We're going to buy a new car, whatever the healthy spouse needs. But let's say after we do that, we still have $300,000 left. $300,000 that's preventing the ill spouse from qualifying for Medicaid. Well, under the Medicaid rules, we are permitted to take that entire $300,000 and convert that into an income stream for the healthy spouse by buying what's called a Medicaid-approved annuity. And as soon as we buy that annuity, the ill spouse is now resource eligible for Medicaid. Medicaid begins paying for his or her care. And that extra $300,000 that we used to buy the annuity, that money is all going to come back in monthly installments to the healthy spouse over a period of several years. And as he or she receives those payments, Medicaid will consider those payments to be income to the healthy spouse. And the Medicaid rules say that the healthy spouse's income is exempt. So as she gets those payments of $3,000, $4,000, $5,000, $6,000 a month, whatever they are from this annuity, all of that is considered income. And the healthy spouse gets to keep 100% of it, okay? So I know many of you are probably thinking it's too good to be true, right? How can we do this? Well, for these annuities to work, they have to meet a whole host of requirements. One of which is they must be irrevocable. So when we're converting the cash into income, that whole situation must be irrevocable. So if we buy an annuity, we can't revoke it. We have to wait until it pays itself out over the course of 3, 4, 5 years, whatever the case may be. But we also have to name the Commonwealth of Pennsylvania as the beneficiary of that annuity. So what does that mean? If the term of the annuity, let's say, is 5 years, so it starts paying the healthy spouse back over the course of 5 years. And if the healthy spouse dies during that term of repayment, whatever money remains in the annuity has to be first used to repay Pennsylvania for all the Medicaid dollars they've expended. And then if there's anything left, it'll go to the contingent beneficiaries, okay? So there is that risk, But by not doing an annuity like this, you're guaranteed to be paying privately for a very long period of time. So although it's a risk that many people, once they learn about it, how it works, they're willing to take that risk, okay? The one last thing I'll mention about that sort of planning with Medicaid annuities is it is only planning in crisis. A person should never buy what's marketed as a Medicaid compliant or Medicaid friendly annuity while they're healthy. So if any financial advisor ever tries to offer that, and I'm not saying they are doing that, but there have been some in the past, don't buy it because it's not a good investment. It's a strategy to be used in a crisis. You do not need to buy a Medicaid compliant annuity in advance. It's purely a crisis planning strategy. The last area I want to address briefly before we go to questions is special needs planning. This is considered an area of elder law because it's used to allow a person to maintain public benefits. So most often, in the context of what we do in elder law, special needs planning is a way that a person can allow an inheritance to pass to a child of theirs who has special needs without disrupting the public benefits that that child is receiving. So years ago, if a person had a child who was receiving SSI and Medicaid, of course, there's severe resource limits that that person has to abide by to maintain their public benefits. So many years ago, parents, unfortunately, would disinherit those children. They would leave their share to the brothers and sisters and cross their fingers and hope that those brothers and sisters would take care of their sibling with a disability. Well, fortunately, we don't need to disinherit a beneficiary who has disabilities at this point, because what people can do in their wills, they can establish what are known as special needs trusts, which are designed to hold an inheritance or resources for a beneficiary with special needs without jeopardizing their eligibility for SSI, Medicaid, or any other benefits that they may be entitled to receive. So it's an important component of estate planning that we can plan to leave an inheritance to a beneficiary that has special needs without any fear of that person losing their public benefits. So that is another important component of what, as I said, what elder law is. So at this point, I'm more than happy to answer any questions that anyone in the audience or anyone online would have with regard to anything I talked about this time or even last time.
Oh, Kevin, that
Yep.
special needs annuity,
Sorry, our online audience can't hear you.
that special need annuity is only for children, not for grandchildren, are they?
The special needs trust, you mean?
Yeah.
Special needs trust can be used for grandchildren as well as children. So actually it can be used for anyone. So if you have a beneficiary in your life, whether it be a child, a grandchild, niece, nephew, friend, whatever the case may be, you can create a special needs trust for that person and allow them to receive an inheritance without losing their benefits. So
And
it's
one more
very
question.
flexible.
Yeah, one more question. When is it unadvisable not to buy a trust? If you have enough money, you could pay as you go. Is that advisable to do that?
Some people do that, that's right. So, it's kind of different for every person, I would say. There's no hard and fast number, but at some point, trust planning really doesn't make sense. So if a person has, millions of dollars, let's say, that generate monthly income for them that is equal to or exceeds what the nursing home costs, it doesn't really make sense to plan to qualify for Medicaid. So, what I'm doing in my practice is I'm not usually, there's this kind of saying, are there millionaires on Medicaid? Not many. I mean, that's not what I do. And most people that have those types of resources, they're not interested in qualifying for Medicaid or planning such as that. But I will tell you, I've had people over the years who said to me, they don't want a dime to be used on nursing care. And I've tried to dissuade them from setting up a trust, and they did it anyway. But I would agree that most people who have a high net worth, a few $1 million that are going to be generating income, that equals the $12,000 or $13,000 that a nursing home costs per month, it doesn't really make sense to establish a trust to qualify for Medicaid.
You see many people with that around here?
Not too many.
Yeah, okay.
They are around here, though.
Yeah,
Are
okay.
you looking to be adopted?
So if you set up the Family Asset Protection Trust and you move all that over, what about your monthly expenses? How does that work? And does the trustee, do they give money back, or how does that work?
That's a great question. So as far as your monthly expenses, the first thing I would say is you're not going to put everything in the trust. So you don't put your income in the trust, you don't put your checking account in the trust, and you cannot put retirement money in the trust. So if you have an IRA or a 401k, 403b, none of that goes in the trust. So the people who are establishing a trust still have 100% access to all their income all the time. It never flows through the trust. However, there are situations where, let's say a person ends up using their entirety of their retirement, and now their income drops precipitously, and they have all this money sitting in the trust, and they might need that to pay some of their bills. Yeah, there's a way that the trustee, there's a process that the trustee can take money out and take care of things, but you can't do it on your own. That's the bottom line. Once you put something in the trust, you can't take it out. That would violate the terms of the trust. But we never advise people to put everything in the trust, and it's not even possible to put everything in the trust.
I just want to clarify, when you're saying the trust, you're talking irrevocable trust.
Yes, irrevocable. A lot of people have heard of revocable living trust as a means to avoid probate. And I will tell you that that offers zero protection from long-term care. In my practice, I've been, again, practicing about 23 years. I can count on one hand the amount of revocable trust I've done, because they simply don't work to meet people's goals. People's goals are to protect their home and their assets from long-term care, and that type of trust must be irrevocable. Yes. You follow up?
Just to go back with that. So in terms of having assets, if you thought you didn't need it for the nursing home and you had like a revocable trust, but for the house, you said, well, how do I protect that from a nursing home? Can you split the difference on that and say, like, you know, the house is protected, the other stuff, I think we have enough assets that it wouldn't be an issue?
Yeah, there's different ways to protect the house. You don't have to use a trust. So basically, to protect the house from long-term care, which would basically be to protect it from estate recovery, you just have to ensure that the Medicaid recipient is not the sole owner of the house. So it can be protected by owning the house jointly with someone else with the rights of survivorship. It can also be protected by doing what's called a life estate, where you sign a deed. Let's say instead of doing a trust, you can sign a deed where you retain the legal rights to live in your home for the rest of your life, but you give your children what's known as a remainder interest, which means the day you die, it's their house. It does not go through probate. And if you do that, the house is also protected from estate recovery. But anytime you add someone's name to the deed or do any kind of transfers with your title to your property, you are triggering that 5-year look-back period for Medicaid. So you don't want to wait until right before going into the
Right.
facility.
And if the children are married, where does the spouse fit into what you just talked about?
So if the children are married,
excluded or what?
it really is going to depend on what state the children live in, honestly. But in Pennsylvania, if you transfer an interest to your married children and they don't add their spouses to it, their spouses only acquire a very minute interest. But with a trust, if you put your home in trust, their spouses get nothing. And if you do what's called a life estate, their spouses acquire nothing either.
Thank you for that.
Sure.
So that life estate is a better option to deal with your house, get it away from for Medicare by putting give your kids the house, but buy a life estate, put a life estate on your name on it.
So your question was kind of like, is the life estate better? And I'm hesitant to say better because every situation is different. So I'm gonna give you an example. A life estate works great if you never want to sell your house, right?
Right.
I have a lot of clients who say, my house, it was my parents' house, it was my grandparents' house, I'm never going to sell. So for those people, a life estate might be a great option, right? However, if you could predict the possibility of selling your house in the future, a life estate becomes less valuable. Because with a life estate, if you want to sell your house, now you need the permission of all the children who are on the deed and their spouses. So now a lot of people have to be involved in whether or not you sell your house. And when the house is sold, the proceeds are allocated to you and your spouse and some to each of your children who are listed on the deed. So it really is so much driven by individual circumstances as to what's the best option. For some people, life estate is the best option. For many, it's not. The trust is still a better option for many.
Can we take some questions online just because our
Yeah,
chat's-
just one more quick one. With what you just said, the tax consequences, like, I know there's something out there, like, if my wife and I sold our house right now, we've been there, I think it's 2 years. Anyway, you can write off capital gains. Is that negated when you start putting the children in, if you did ever sell the house? Where
It
does that?
depends on what sort of strategy you use. If what you're talking about is the exclusion on capital gains for your primary residence, and if you sell your primary residence, there's no capital gains for you and your spouse. If you put it in a trust and your children inherit the property, no capital gains either. There's a step up in basis. If you do a life estate, also no capital gains. You get a step up in basis upon your death. They have to inherit it. That's the key, right? But if you give your house away, just sign it over to your children, it's a carryover basis, and now there's tremendous capital gain when they sell the property. Yep, you're welcome.
So we do have a few questions online.
Sure.
What makes the difference whether a single or widowed person can have only $8,000 versus $2,400?
That is a fantastic question. And what it comes down to actually is their income. So under the rules, if their monthly income is less than $2,901, they get to keep $8,000. If their monthly income exceeds $2,901, they can only keep $2,400 in countable resources. So it's based on their income.
Great, thank you.
Sure.
Next question. For a single person who may require long-term care, if they chose to sell their home, are there any penalties or risks?
So if a single person who might require long-term care sells their home, what they're doing is they're converting an exempt resource into countable cash. So if that person is already in a nursing home and receiving Medicaid benefits, once the house is sold, it's no longer exempt. So let's say they receive $200,000 from the sale. They sell their house, they now have $200,000. They're no longer eligible for Medicaid until they spend that back down to $8,000 or $2,400, as the case may be.
Thank you.
Sure.
So, and I believe you may have answered part of this question. What occurs if you need long-term care within 5 years, meaning it's too late for planning? And I believe you got into that with the crisis planning?
Yeah, so we like to say, my partner Brenda and I like to say, it's really never too late, because even if you haven't made gifting and you haven't bought long-term care insurance, if you have assets, there are ways legally to expedite your eligibility for Medicaid and protect about half of your remaining resources. Now that's assuming you've made no prior gifts. So if a person has made no prior gifts and now they find themselves in a nursing home, someone like us, like certified elder law attorneys, can help that person save about 50%. They would make a gift right then and there with our advice on how much to gift, and then we would use that Medicaid annuity to pay privately for their care during the corresponding ineligibility period.
And staying on the topic of annuities, are annuities an option for single individuals?
Annuities are an option, but what they're used for is to just pay through an ineligibility period, not to convert a countable resource into income. So again, if I go in a nursing home and let's say I have $300,000, an annuity is going to allow me to save about half. I might give away $150,000. That's going to create a penalty period of, let's say, 10 months, 12 months. And then I'm going to use the remaining $150,000 to buy a Medicaid annuity that will be used to pay for my care during that ineligibility period.
Okay. They're asking to please talk about how to handle the crisis situation for your single parent who didn't do any planning and who did a lot of gifting.
Oh, yeah, that gets complex. So basically what we have to do is find out how much was gifted away during the last 5 years. So the first thing we would have to do is review 5 years of their bank statements, add up all their gifting, and find out what we have to contend with. The hope would then be that the parent has enough money remaining in their name to pay privately for their care during the ineligibility period created by the gift. If they don't, perhaps some of the gifted money can be returned and the penalty period could be shortened. We would also look to see whether any of the gifting was exempt, because sometimes, I didn't get into this during the scope of today's presentation, but certain gifts do not create any ineligibility. So if you gifted money or an asset to a child who's on disability, there's no penalty for that. If you gifted your house to a child caregiver, there's no penalty for that. There are other loopholes and exceptions to the gifting rules that we would have to look through to see if that situation, in that situation, if we could take advantage of any of those specific loopholes.
Okay, now I have a two-part question here, and this is our last one online, and we'll send it back to the room. Can you clarify what can be put in a family protection trust, and where are the best places, or can you recommend the best companies to purchase long-term care insurance?
Okay, so the first part is a much easier thing for me to answer. So the assets that you can place in a family asset protection trust, let's start with real estate. So your primary residence, if you own land, if you have an apartment building, a lake house, everything like that, any kind of real estate can go into a trust. Also, life insurance, because life insurance accumulates a cash value that's at risk if you go into the nursing home. So life insurance policies. Also stocks, mutual funds, commodities, options, savings bonds, most types of annuities, certificates of deposit, savings accounts, cash. Those are all the kinds of things that can go in the trust. What can't go in the trust is retirement money. So no IRAs, no 401ks, no 403bs. You also don't put tangible items in the trust. You don't put your car in the trust. You don't put your diamond ring in the trust, things like that. So most of your assets can go in with the exception of retirement money.
Oh, how about the...
Oh, the second half, yes. What are the best companies for whom you would purchase long-term care insurance? Because I don't sell long-term care insurance, I don't think I'm qualified to answer that. I will say that my best advice to someone who's considering long-term care insurance is to meet with a professional who specializes in the sale of long-term care insurance, someone who can sell multiple types of products. I will say I can't really recommend a company, but hybrid policies, in my opinion, are the way to go. So you're buying a life insurance policy with a long-term care rider. So no matter what happens, whether you use it or not, your family is going to receive a death benefit at some point. Were there any other questions here in Scranton in the audience?
What's the question? It's unclear about that emergency trust. You're in a nursing home already, and could you establish a trust then?
You can. You just have to make sure that you can fund it, but you have to make sure you reserve enough money to pay privately for your care during the ineligibility period that's created. So again, that's the situation where we can probably gift half of your estate into the trust, and we have to spend the other half of your estate by buying a Medicaid-approved annuity, which will be used to pay for your care during the ineligibility period.
So if you have enough assets, you don't have to have a trust, just pay as you go.
Correct.
Okay.
That is correct.
And we just have one last question for
Sure,
you, Kevin.
sure.
Someone is asking if your company only services certain counties in Pennsylvania, or do you service all of Pennsylvania?
We do service all of Pennsylvania. Thank you for that question. We have offices in Lackawanna and Luzerne counties, but we travel frequently to the surrounding counties, and I've had clients really all across Pennsylvania. Usually what we do is if someone is from a far distance, the initial meeting is usually done via video conference or telephone, and then we make arrangements after that to get documents signed and move forward.
Okay, well, we'd like to thank you for your time today, Attorney
My pleasure.
Grievous. And for those online, we did record this. We'll be sending it out as well as the handouts that were handed out today. And thank you so much and have a great evening.
And one more
Thank you.
thing. If you'd like to go over and meet Selena, she is from Life Geisinger, and she has some information about some care for the elderly.
I'm going to endorse Selena. You should absolutely talk to Selena. I've known her for a long time.